Okay, abusia be mma kwa aba sonko so e ba POG Media so. Ye dem be political highway ne so highway ne de ensam bebre wo so ayen so ya Japan se be me abedwafo no ahu de ekọ ene de eba abusia live update e wo Accra High Court eye ene ye kokọ piem wo no sisi ano NPP for elusi hope abusia ene Accra High Court etenase no bibia ekọ in favor of the NDC asisi amasan so Adjourns eye case no asanso omo adjoin the case no asisi ano NDC nioma na ekoso no omo kura full evidence ntino omo they are still on their grounds abusuya NPP for ne de omo hu de omo ye omo ntino ye ko Accra high court on the tension bebre o asisi ano NDC for a leader court nso no kire NPP say masa omo ntumi emba embe also omo say omo ntumi emba embe use omoden criminal tactics bi anase omuntu be use any ambush tactics bi na omon fam be chinchim omonsa NDC for no e ka kire omo a abusua enye easy kra yensa embre no me yanko na yanko nkoti ensema course high court de no ensema call high court ne so no ensema course wo ho no eno no ye de bremo ene ensema NDC funds no editudwa am say they won't allow any ambush tactics bia ewo court wa enye easy kra ebede abedwafo ase yanko na yanko nkoti medamase.
The issues here basically are that the NPP, the Electoral Commission, and the NDC came to court on 4 constituencies: Techiman South, Okaikwe Central, Ablekuma North, and Tema Central. The plea of the NDC, of the NPP who are plaintiffs in this matter, is that the court should order the Electoral Commission to go back and collate results in these constituencies. These constituencies already, the results had been declared for the NDC. The NPP earlier came to the court for a mandamus application that calls for a collation, or what has become to be termed as recollation. After that, these constituencies were declared in favor of the NPP, except for the Ablekuma North constituency, where the officers were not able to complete the collation exercise. However, the NDC went to court saying that at the first time when the mandamus application was being heard, their arguments were not listened to, and that their right to natural justice, which is a right to be heard, was not upheld by the court. As a result of that, the Apex Court decided to quash the decision of the High Court. The Apex Court, however, directed the parties to return to the High Court to rehear the mandamus application to decide whether or not the EC will go back and recollate or collate the results. But before that application could be moved, the NDC's lawyer, Godwin Eduje Tameklo, moved a preliminary objection, arguing that the court lacked jurisdiction to hear the matter because of the approach that the NPP used. He argues that if you look at Section 16 and Section 20 of PNDC Law 284, People Representative Law, as amended, any issue as to whether or not a person has been validly elected or as to whether certain results should be cancelled can only be made by way of a petition to the court. Because of that, any other attempt to use any approach, such as a judicial review, as the NPP used in this manner, is a way of circumventing a proper hearing of the matter where evidence will be properly heard. The NPP, however, opposed this and argued that their case does not deal with the issue of declaring or cancelling results. Their case deals with compelling the Electoral Commission, which has a public duty, a duty to conduct elections, to supervise elections, to collate and declare results. They say that from their observations and evidence available to them, the Electoral Commission has not done that. And the Commission itself has admitted to not doing that. As a result, the court should compel the Electoral Commission to go back and do its work. The court, after listening to the parties in the case, including the Electoral Commission itself, whose lawyer also supported the idea that the mandamus application should be heard in the first place, decided that it will adjourn the case to tomorrow, January 1, 2025 at 10 a.m. and it will give a ruling. Based on the ruling of the court, we will know whether or not the mandamus application will be heard. If the court decides to hear the mandamus application, then it means that the court will now come and decide whether the EC should go back and do collation. If the court decides to uphold the preliminary objection, then perhaps this may be the final route for the NPP. As far as this route is concerned, of course, they may have the option of appealing all the way to the Supreme Court. But of course, here on Channel 1 TV, we'll bring you up to speed on all happenings here at the High Court as far as the issues are concerned.
We raise an objection, preliminary objection, to their case that they filed. We thought that it's a wrong method they've used. They are using ambush tactics, backdoor window, to force the arms of the state institution, EC, to do their bidding. That is a trick they are trying to do. The people have voted, the returning officers have done their work. The law, the EC, has given those powers per the CI 1272 to returning officers to declare, collate and declare parliamentary resource. So that power rests with the returning officers. Okay, it doesn't rest with the commissioners, Madam Jean Mensah and the other commissioners. They don't have those powers. It is the returning officers. So when they finish their work and declare somebody winner and you are not satisfied, POG law 284, okay, subsection 16 and 20, you come to High Court and file a petition against those declarations with enough evidence so that the court can set it aside, the declarations, or ask for this.
But your opponent said that there was no official collation and declaration of the results, so to say. But you are saying there were collation and declaration of the results, and it went in your favor. Is that what you are trying to say?
Your media houses carry the declarations. Your media houses, they carry those declarations live. It was done live. It wasn't done under somebody's bedroom. It was done at the collation centers. Live cameras, policemen standing there. And they held the hands of the various candidates, having been properly elected and declared. You get my question? That is what they have done. They have done their work. So that mandamus they are asking for, that work was done. Not that it was done. And they were declared officially at the collation centers. So if you are not satisfied, you know the path to go. You don't come by mandamus and saying that they should go back and do something they have done already. They have done it.
In Summer Central, the argument of the NPP applicants is that the returning officer who declared Ms. Bright the winner was not the official returning officer who should have done that, and so it makes it null and void.
It is only the High Court that can make such announcement or pronouncement that it was null and void. Not Madam Jean Mensah and her commission. They don't have that power. They should show which part of the law that allows them to sit in their office and say it was done in error, and therefore they are not upholding it. Tell me which part of the law. CI 127, the 63 pages, which part of the page is saying that Madam Jean Mensah has that power. We are not in the jungle. Let's do things legally. That's why the law court is here. The path for them to do that here, High Court, come with a petition. Let the judge set it aside, and then we now get whether it is true or not. It doesn't lie in their mouth. What they are doing is illegal. It's a lawless institution that we are now having, and we must correct them. The EC first become a very lawless institution.
They also claim that what was done per the ruling of the court from the previous courts, which compelled the EC to go on with the declaration, was not a re-declaration, but was the conclusion of the collation and declaration of the elections. Do you agree with them, or what is your stand on that?
There is nothing like that. We don't have anything like that in our books. The CI 127 is very clear. Just go and read Regulation 43. You will see the procedure used in collating and declaring results. The presiding officers haven't satisfied themselves with their procedure, went ahead and declared the results. If you are not satisfied with that, you don't sit in your office and said they didn't do this, they didn't do it. Let the judge see it, not you, the commissioners. They don't have that power. That has been our position all along.
Do you expect tomorrow's ruling to go in your favor?
Of course, we have just given the evidence. We have given enough evidence. The mandamus was meant to do what? To ask them to do an action that they thought they have not done. But those actions were carried out by the returning officers, not Madam Jinmensa. They have done their work. They are finished. And they have sent their results to them. If they are not satisfied, guys, let us battle each other through a petition. We'll battle each other. But you don't come through this back door. This is a back door method. Ambush tactics. We won't allow it. It's a very, very unknown procedure to our laws. We won't accept it. That is why we are here. You see, we are not lawless. NDC is a very law-abiding institution. That's why we are here. If we were to these people, they would have used state guns to go and ransack the place and declare themselves winners. 2020 is evidence. You saw what they have. They stole 5 seats through guns, kill people. Have we done that? And say we should go to court. They don't want court.
Alaji Computer, thank you so much for your time on GBC. So there you heard Alaji Computer, one of the NDC legal directors for the elections, and saying that their party is a lawful party and will do this through the legal means and will not use violence in getting justice or getting their case heard, basically. So that's it. So from the courts will decide on the preliminary objection raised by the NDC tomorrow, 1st January 2025, as to whether it has the jurisdiction to sit on that application or not, and whether the NPP MPs brought a mandamus, an election petition in a disguised form, or whether it's mandamus is also allowed or by the courts for this kind of hearings. So here we have it. This is the court, this is the High Court, and this is what transpired today. And mandamus was to have been heard this morning by the General Jurisdiction 2 of the Division of the Accra High Court. The case came off. It was heard, but prior to the hearing, the NDC side of the interested parties brought an application, raised preliminary objections to the mandamus application by the NPP MPs, and arguing that the court did not have jurisdiction to hear the matter because this matter was the mandamus application by the NPP was an election petition in disguise, and that is not the right means to bring such an application to the High Court. They should have brought an election petition to the High Court and not a mandamus. But the NPP, a lawyer for the PCs, argued that an election petition would have been brought to the court if the collation and declaration of the results were officially done. But in the case of the 4 constituencies, they were not. The collation and declaration of the results were not officially done. So the only means by which they could have the court compel come to court to compel the EC to continue with the declaration and the pronunciation of the results was through the mandamus application, which the NDC side disputed by putting up the preliminary objections, raising preliminary objections to the mandamus. This, the court said that it was going to decide on tomorrow, 1st January 2025, if God wills. So basically, that's what happened in court this morning. After court, you heard some of the lawyers say they couldn't make statements on the matter because the ruling of the court is not yet out. You also saw the NPP side of the parties making various arguments and statements about this whole thing. So the genesis of this whole matter is that the NPP, after the December 7 general elections, came to court. That's 6 of its parliamentary PCs came to court with an application for mandamus, asking the court to order the EC to finish the coalition and declaration of results in those 6 constituencies, those affected constituencies. but the NDC, hearing of the mandamus, came to court and served a rejoinder, filed a rejoinder to be joined to the suit. But then on the 20th, when the High Court jurisdiction, General Jurisdiction 13 heard the case, it failed to grant NDC the hearing it sought because it said the timing was not expedient for the court to hear the NDC looking at the importance or the urgency of the application that was heard that day, and so it refused the NDC party MPs their request to be heard on that day. So on the same day, when the court, after the court ruling, NDC went to the Supreme Court with an application for certiorari, asking the Supreme Court to quash the decision of the High Court for the 6 PCs, the order by the High Court for the EC to collate and declare the results of the PCs in those affected constituencies. However, and the Supreme Court, the Supreme Court upheld the request by 4 of the constituencies and asked that the High Court, another judge in the High Court, hear the matter and hear the NDC side, rehear the mandamus by the NPP side, and also hear the application by the NDC to make a final determination of the case. And so this was done, and that is why we are here today, and that is what we heard in the morning when the NPP&EC raised a preliminary objection to the mandamus application by the NPP. Subsequently, where the judge made a ruling that he's going to decide on that matter tomorrow in the morning at 8 a.m. So basically, that is why we are here in court, and that is what we witnessed this morning. So as we see in the background, some members of the NDC and the NPP are here arguing and disagreeing, over whatever we don't know, we can't tell. But initially, the whole place was a quite peaceful mood earlier. They were each trolling or teasing each other, but now it's turning into a bit of a conflict here. But the police is here, so order is in place, and who is on there? What is it? You know it.
We are coming to court. We are coming to court tomorrow. No, I'm saying we are coming to court tomorrow. GBC.
Yes. Can we do a quick interview? Can we do a quick? No, but this is for social media. This one is for TV, please. Call Letitia for me. Letitia.
Okay, abusunya we ne ensema ekoso ewo Accra High Court enye izikra NPP for elusu hope still ano NDC ewo leader enye izikra beda masesa pene kokoti sa audio we edemai aha POG Media so beda mase